All right, for the record, today is Thursday, November 16th, 2023, and this hearing is being conducted both in person and telephonically using Microsoft Teams and is currently being recorded. If you have technical difficulties or for some reason get disconnected and are not able to rejoin the hearing, please contact me or email me. Once again, my email, you all probably already have it, but it is robin, ROBIN .POPE @cot.tn.gov, or otherwise just try to rejoin your link for today to make sure we can get you back into the hearing. We are present before the Tennessee Assessment Appeals Commission, who have been appointed by the State Board of Equalization to review initial decisions and orders of administrative judges and other related matters. My name is Robin Pope. I currently serve as the Executive Secretary for the State Board of Equalization, and I'm designated to sit with the Assessment Appeals Commission as a hearing officer. As a hearing officer, I will preside at this hearing, rule on questions of the admissibility of evidence, advise the commission members as to the law of the case, and otherwise ensure the proceedings are carried out in accordance with law. So mostly I'm just here to make sure the show goes along and we get moving through proceedings today. However, and importantly, I do not partake in deliberation. So I am not a decision maker during today's hearing. The decision makers are our commission members who we will introduce in a moment. I'm just here to sort of make sure we stay organized and on task. And I'll go through introductions. First, to my left, if you can see me on video camera, and I'll have him introduce him so you can hear him on the microphone, is Mr. Miles Crandell. Miles will serve as, Mr. Crandell will serve as counsel to the commission, and he will assist the commission with questions during deliberations and offer guidance regarding the legal sufficiency of their conclusions or their decision today. So Miles, can you give us a shout on your microphone to make sure we can all hear you?
Good afternoon.
All right, looks like I got a nod, so I think that works. I'll now ask our members of our panel to introduce themselves for the record. First, we'll start with our presiding member, Mr. Phil Russ.
My name is Phil Russ.
And just as a reminder, just because I forgot, if anytime you can't hear anyone or you think you're missing something, especially for our virtual setting, please just speak up and just say, hey, I can't hear you, or ask us to repeat something. I just want to make sure everyone can hear and fully participate in today's proceedings. I got a late entry here with Miss White with the assessor's office. Want to make sure she gets in. Miss Palmer. All right, we'll continue on with Mr. Osborne.
My name is Don Osborne.
Sorry.
That's okay. And then our final commission member is Mr. Tim Profit.
I'm Tim Profit.
All right. Mr. Russ, as chair of the commission, will preside at this here during deliberations. Mr. Russ, as chair of the commission, will preside, be our presiding member, and he will oversee deliberations and concur in the final written order. All appeals to be heard today are to be conducted based upon the record available before the administrative law judge during the prior hearing. Pursuant to law, the Assessment Appeals Commission may affirm the decision of the hearing examiner, that is the initial decision in order, or otherwise remand the case for further proceedings. The commission may reverse the decision if the rights of the petitioner have been prejudiced because the administrative findings, inferences, conclusions, or the decision is otherwise 1, in violation of constitutional or statutory provisions. That is, did the judge follow and apply the law correctly? 2, made upon unlawful procedure. That is, did the judge not follow some proper procedure, or was there some sort of abusive procedure? 3, the decision was arbitrary and capricious or characterized by abuse of discretion or clearly unwarranted exercise of discretion. This one's so much more explanatory, but essentially, was the decision arbitrary? Or 4, was the decision unsupported by evidence that is both substantial and material in light of the entire record? And so, and what that means is in determining the substantiality of the evidence, the commission can take into account whatever in the record fairly detracts from its weight, but shall not substitute its judgment for that of the hearing examiner as to the weight of the evidence on questions of fact. So that's the legalese basis, but essentially the factor is, was there a factual basis in the record for the decision of the judge? The commission cannot replace their judgment for that of the administrative judge on questions of fact, but they are not required to ignore inconsistencies of evidence or evidence in the record that may suggest two answers. They can acknowledge that and see that in the record. However, if the administrative judge made a finding of fact, they cannot replace their judgment for that of the administrative law judge. This means no new or additional facts, testimony, documents, or other evidence may be presented to the commission. You'll notice today for all our parties that I'm not asking you to, swear an oath. That is because there is no testimony today. We're just hearing arguments about the administrative law judge's ruling. So there is no testimony or additional documents. You may, however, refer to excerpts of the certified technical record or the record that we gave you in advance of today's hearing. The same copy was provided to our commission members, and I have a physical copy with me as well for ease of reference. For those on our virtual call, I can also share my screen and highlight portions of the record. That is supposed to be a useful tool for reference purposes during today's hearing. And that is the only thing we will be looking at if you need to refer to anything. Like I just stated, a copy of the record was previously presented to the commission members using Microsoft Teams and email, so using Microsoft Outlook, OneDrive, and email, along with any written argument submitted by the parties in each case, as well as the audio recording from the prior hearing. I also, like I said, have a physical copy of each initial decision in order for our commission members today. We will proceed one case at a time, one immediately after the other, taking breaks only as necessary. I would normally call roll, but it looks like we are all here, so I'll kind of dispense with that for now. Unless there's a pressing concern or someone needs an immediate break, we will go ahead and get started this afternoon. I only have two appeals on our docket. That is for Rebecca Muska versus the Shelby County Assessor's Office, and that is for Doubletree Memphis versus the Shelby County Assessor's Office. We traditionally go in order of who has identified they're going to take the least amount of time, and then we end with those who identified they need extra time to present their arguments. I believe if my notes serve correctly, Ms. Muska identified she didn't need as much time as Doubletree identified they wanted. And so we will start with you, Ms. Muska. I see you nodded your head. Just a reminder, these proceedings are really informal. Board members are allowed to ask questions at any time. However, once we've heard all the arguments on an appeal, I will briefly describe the charge to the Assessment Appeals Commission before handing it over to them for deliberations. Once we enter deliberations, there's no more communication between the commission members and the parties. If the commission member does end up having additional questions, you have to exit deliberations and reopen the record. Prior to each appeal, I will briefly and try to quickly as possible read a copy of the initial decision in order that's under review and recite it into the administrative record today. From there, like I said, these are informal proceedings. Generally, we will hear from the taxpayer first. And then we will hear from the assessor's office, and then we will return to the appellant, that being the taxpayer, and go from there. So I'll kind of briefly stop reading my script and look around and make sure there's no one needs a break and we're otherwise ready to continue. I'll look to our commission members first. So now you're all ready? Okay. And then from the assessor's office or Ms. Muska, if either of you are not quite ready yet, just holler at me, but otherwise I'll read through some of the documents we have here for this case. We're not hearing anyone. So I am looking at the certified copy of the technical record for the matter of, this is entitled Rebecca L. and Kenneth Muska. I apologize if I've ever mispronounced that, versus the Shelby County Assessor's Office. Specifically in the certified technical record, let's see, we've got the order was as noted as being issued originally on March 29th, 2023, and is on page 47 of that certified technical record. It's on a different page of the notice of the administrative record that was filed for today. Let me get over to the order we are under review. Importantly, this is the initial decision in order was APD case number 53.01-230190J. This is for SBOE number 140552, the parcel ID being D0123-00028C. This is for tax year 2022. The order reads as follows. Statement of the case. The Shelby County Board of Equalization has valued the subject property for tax purposes as follows. Land value of $40,600, building value of $184,400, total value $225,000 for an assessment amount of $56,250. The taxpayer filed an appeal with the State Board of Equalization on September 13th, 2022. The undersigned administrative judge conducted a telephonic hearing of this matter on February 13th, 2023. The appellants, Kenneth Muska and Rebecca Muska, were represented by Rebecca Muska at the hearing hereinafter the taxpayer. The Shelby County Assessor of Property was represented by Staff Appraiser Elmer Moore hereinafter the Assessor's Office. Summary of evidence. The testimony of the taxpayer's representative, Rebecca Muska, and Shelby County Assessor of Property Staff Appraiser James Polk, and the following exhibit. Exhibit 1, the Assessor's Office's Valuation Analysis. Findings of fact and conclusions of law. The subject property in this appeal consists of 7.73 acres containing a house located at 715 Chaser Road in Millington, Tennessee. The taxpayer contended that the subject property should be valued at $195,500. The assessor's office contended local board's value of $225,000 for the subject property should be affirmed. The basis of valuation set out in Tennessee Code Annotated Section 67-5-601 subsection A is that the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. At the hearing, the taxpayer's representative, Rebecca Muska, testified that the property has had no improvements since 2016 and that the assessor's office's valuation failed to take into account the nearby abandoned mobile homes and a nearby neighbor running an auto repair business out of his home. Further, the taxpayer testified that the assessor's office's comparable sales contain better and wider roads than the subject property. The assessor's office's representative, James Polk, testified that under its valuation analysis that the subject property was adjusted accordingly. The taxpayer's testimony provided no basis or evidence to support a lower assessed value. Sorry, did I miss a page? I was from 2 of 3. James Polk testified that under its valuation analysis that the subject property was adjusted accordingly. And then page 3 of 3, the taxpayer's testimony provided no basis or evidence to support a lower assessed value for the subject property. Based on the valuation analysis provided by the Shelby County Assessor's Office, I believe the local board's valuation should be affirmed. Respectfully, the evidence introduced by the taxpayer is inadequate and cannot be relied on in this matter. Therefore, having failed to carry the burden of proof in this matter, the local board's valuation is affirmed. It is therefore ordered that the following values be adopted for tax year 2022. A land value of $40,600, a building value of $184,400, a total value of $225,000, and an assessment of $56,250. is then signed off on March 29th, 2023. And available remedies available to the taxpayers concluded in the final page, including appeal to this body, which is why we're here. We then have a couple of other, I will just note, after that order, there was a petition for reconsideration of the initial decision and order, and a petition for stay of the initial order, followed by a follow-up from Administrative Judge Jerome Cochran on April 6, 2023 on those two. Briefly just want to get to that page and note for the record what the outcome of those were. Jerome Cochran ordered on page 60 of the consolidated record. This is just sort of administrative history of this case. That on March 29th, 2023, the undersigned administrative judge ordered a tax valuation for the aforementioned case. On April 3rd, 2023, the taxpayer timely requested for reconsideration. The taxpayer requested reconsideration based on arguments that the administrative judge did not take into account certain facts in her testimony regarding the property valuation, and that the assessor's office's testimony was not accurate. Unfortunately, the taxpayer's arguments are the same ones made at the hearing and are not supported by any new evidence and provide no basis for reconsideration of the initial order. The taxpayer failed to provide any statutory authority or case law supporting his contention regarding the property tax increase from the previous year. The taxpayer's testimony regarding the subject property's valuation in 2016 is not relevant to this case and has no bearing on the subject property's valuation. Further, the administrative judge found the assessor's office's valuation analysis with his adjustments to be more reliable indicator of the value of the subject property. It appears that the local board took into account the taxpayer's issues with surrounding properties when it lowered the subject property's valuation from the initial valuation of $275,500. The taxpayer having failed to provide any new evidence, statutory authority, or case law that would warrant the setting aside of the initial order, the taxpayer's petition is not well taken. Accordingly, the taxpayer's petition is respectfully denied. Let's see, notice. And then we have the appeal to this body, which is before you, and in your packet, the basis for that appeal. I read through that administrative history just briefly as well, just to point out that this body is an appeals forum, and so this is an appeal of the action of that lower administrative law judge. We have both the initial decision and order where he made that initial valuation, and then I pointed out the petition for stay and petition for reconsideration to acknowledge the just that administrative history both exists, and that you heard that order for reconsideration was denied. There's sometimes confusion about what is being reviewed. I just want to let you know both are part of the record. The initial decision and order is a substantive decision on the hearing and the merits and the evidence presented, and the subsequent order on petition for reconsideration just acknowledges that the judge received the petition for reconsideration and also still denied it based upon those arguments. It's an administrative remedy available in this forum to have a decision reconsidered. With that, that is our decision, and we'll otherwise switch over to our parties for presentation of arguments. Let me just make sure here. Yes, okay. Our appellant today is Ms. Muska, and so Ms. Muska, if you wouldn't mind, I'll have you introduce yourself. Before you get too started, I'm going to switch over to the assessor's office to have their representative introduce themselves, and then we'll go back to you for your initial arguments. So just give us a shout, make sure we can hear you. Tell us your name.
Rebecca Muska. I live at 715 Chaser Road, Millington, Tennessee, 38053.
And it sounds like I've been brutalizing your name, and for that I apologize. It's Muska. I apologize for that. I do my best, but a struggle. Thank you. And then I'll now ask the assessor's office to identify who will be arguing for your office during this case.
Hi, good afternoon. Janika White.
Hi, Ms. White.
Hey.
All right, with that, we'll go ahead and get started. So, Ms. Muska, the floor is yours to present your arguments. I usually prompt taxpayers to, if you could identify specifically what you were asking the commission to do. Sometimes it can better help facilitate the commission's consideration of your appeal. But otherwise, the floor is yours to begin.
Okay, thank you. My concern that I wanted to present to the commissioners was that when I read the administrative law judge's decision, I was alarmed somewhat at how my testimony and my documentation was interpreted, I guess is the best word to use, because it was not accurate with some of his statements. It would just in statements in just 2 sentences that it missed the mark, and I needed to clear that up. And I attempted to do that with those other decision reconsiderations, and it just didn't seem to drive home that what he said I was pointing out or trying to present was not accurate. And so that's why I'm here today. So am I allowed to read the part that was my concern and then to correct what I actually testified to, and how it differs from what he said? Am I allowed to?
I believe so. Yeah, you're reading from the just the initial decision in order.
That
the March
you just
23rd.
read, right?
Okay, yeah,
that 3 pages. Yes, sir. Yes, sir. Thank you. So I'm going to read on the page 2 of 3, the 2-sentence paragraph near the bottom, where the judge said, at the hearing, the taxpayer, me, testified that the property has had no improvements since 2016. And I'll pause there because I need to clarify that, because he must have been thinking I was talking about our property at 715 Chaser having had no improvements since 2016. And I wasn't talking about the subject property, my property. What I was talking about there was that in December 2015, Assessor Kenneth Washington did a field review. And then in February 2016, he sent me an email and he said he was recommending that my valuation be lowered for 2016 and subsequent years, 2015 back to 2013, because he now saw the external obsolescence. And so when I made my testimony, I said nothing has gotten better with that initial finding by Mr. Washington in 2016 of the external obsolescence, that it hadn't gone away. It's still there. Nothing has improved. And I guess he thought I was talking about my house hadn't had any improvements. Just for the record, there have been no improvements on our home since it was originally built in 1994. And so what I was talking about there was that the external obsolescence there that Mr. Washington found in 2015 and then recommended a lower valuation in February 2016 was what was surrounding me. And nothing had changed. It had only gotten worse. So that part of the sentence I needed to clarify. And then I'll continue on with the rest of the 2 sentences there. And that the assessor's office valuation failed to take into account the nearby abandoned mobile homes and a nearby neighbor running an auto repair business out of his home. When I made my presentation and with the evidence I submitted for that hearing with the administrative law judge, I had a lot more evidence than just the mobile homes and then the JPEG that I had that showed that a business was now being run out of the neighbor's home. I had other photos that he did not, I don't know if he saw them or he just didn't need to mention them, but it seemed to minimalize the documentation that I was showing of the external obsolescence that was surrounding us. So that concerned me there, because I thought, did he actually get to see all the other photographs that I had submitted? Because there was more photographs of neglect of the property, these abandoned properties that surrounded us. That included the mobile homes, and then the situation which I testified to at that hearing, that we have the upkeep, the maintenance of a private road. And that was sort of worked into another part of his statement, where he said that I testified that the assessor's office comparable sales contained better and wider roads than the subject property. That was misconstrued, because what I actually testified to is that the property owners, which is about 5 of us on Chaser Road, had the responsibility of maintaining our private road. And we didn't ask this upon us. It was a determination made by the Shelby County Road Department. And our road is 12 feet wide. And so I said in my testimony that sure, it would be nice if we had a wider road, because with a 12-foot wide road, one car has to stay in place while another vehicle has to get off onto a property owner's grass, lawn, yard, whatever, for the other vehicle to pass by. But that's what we've been dealt. And then the fact that when pavement breaks and ice causes damage to the road and opens up potholes, we are responsible for patching it with cold patch. And so what I said was, we don't have the luxury of the other comparable sales, that they are sitting on public county roads, and they don't have to maintain their roads in front of their property like we do. They don't have to worry about patching potholes with cold patch, because the Shelby County Road Department takes care of them. So I was trying to show the difference, that the comparable sales of the assessor were not like our situation, because it didn't show that they had the same adverse conditions that we had. So I never said that the better and wider roads, and I was just kind of surprised at how it was construed, that I wanted to make sure that the administrative law judge had seen everything that I had of my JPEGs that showed the substance abuse people that are being let out of the abuse treatment center that's called Calvary Colony, that's 7 miles from our property, and that the patients have the freedom to get out. They are not held there by court or any judicial system. They can leave whenever they want to, and they will leave, and they will walk down Bingestown Road into our neighborhood, and depending on what their condition is, they may fall out in the middle of someone's yard off of Bingestown. And the photo that I had submitted as part of my evidence, one had left the center and stood out in the middle of Bingestown Road undressed. And so we have that problem that was really a new discovery for us, as I had testified before the judge as recent as 2022. None of us knew that this abuse center had bought property and was located out here in our neighborhood. So that was the part of his statements that concerned me, because it seemed that he didn't really understand what I was talking about with those two sentences. And so that's basically all I had that concerned me.
Okay, thank you. I'll also ask. I usually ask our commission members if you have any questions of Miss. Is it Mosca?
Muska.
Muska. Okay, at this time.
Mr. Prophet, you want to go first? We'll just go down the line.
Yes, Mrs. Muska, when you talked to the county assessor's office, did they make any adjustments, or did you give them an idea of what you thought the proper value of adjustments would be for this access and issue, as well as I'll just roll it all into one question, as well as the junk and auto business that's on your lane, as well as this abuse center? Did you know of any adjustments, or did you give them an idea of what value that depleted your property?
Excuse me. Had a little bit of hard time hearing you there, but I presented this evidence beginning at the very initial reviews. That's why I was trying to get someone with their office out to do a field review, because they were seeing my photographs, but you really have to be out there in person to really see the situation. And so, yes, I had told them about all of these things. And I'm talking about from initial review to hearing officer, to county board of equalization, all those levels. And because in 2016, Mr. Washington said, this is what I feel it's valued because of all these external obsolescence. In the years from his decision then up to 2021 with the countywide reappraisal, things have only gotten worse. And I was reading up on external obsolescence, and it says it never improves. People can do something to totally get rid of it if that's possible, but there's never any other way to handle it. And so it's always stayed there all these years, and it's only gotten worse. There's been more neglect and everything added to what was already there. That was documented back in December 2015 by Mr. Washington. So yes, I told them, and when I look at that, I don't see how my home and property can go up to $275,500 or even $225,000 when it's that bad and nothing's been done to correct it, and the value set back then was $195,200. So I felt that $195,500 was a reasonable value, considering I've got all this around me and it's not going anywhere. It's going to stay right here.
Thank you.
Mr. Osborne.
Yes, ma'am. How long has the treatment center been in operation there at your property, next door to your property?
We have no idea, the neighbors, and we had at one time a civic club going. We had no idea when it was purchased. We didn't even know that there was land there to be purchased for a treatment center. I had to look it up on the register's website. It's a 162-acre facility. And then people that have lived out here longer than I have said, well, that used to be a recreation center that was connected with the state park, or various people had various ideas what it used to be, and that it had cabins and it had a recreational center or whatever. But we had no idea that anyone had bought it, and it was purchased by Memphis Union Mission. And they have facilities in downtown Memphis where they meet the need of major substance abuse there. But we had no idea that they send the overflow of substance abuse patients out to this facility that they named Calvary Colony. And it's at the T intersection of Ramsey Road and Bingestown Road. We had no idea, not until 2022, when someone told us about it at a civic club meeting.
Okay. And you said it was approximately 7 miles from your home?
Yes, I did that on Google Map to see how many miles it was. Mm-hmm.
That's all the questions I have.
Did you ask the assessor's office if they had considered what Mr. Washington had done and made any adjustments in the most recent reappraisal?
Once that I started the appeal process in the recent reappraisal, my first and foremost desire was to get someone from the assessor's office to come out to see the same things that Mr. Washington did. And they kept telling me that because of COVID pandemic, they couldn't get anybody to come out. And no one was ever able to come out until right before the administrative judge hearing on February 13th, 2023. And they came, Mr. Hall, Hall, I believe. He's the one that came out and he took the pictures as Kenneth Washington had done back in 2015. So he was the first and only employee that came out to see what I was trying to get everybody to understand. Okay. And I don't know if I don't know if they made any adjustment. It didn't appear to be that they made any adjustment. The only thing that I believe was adjusted when we had the hearing February 13th of this year with the administrative law judge was they had us down as having a masonry fireplace, and we did not. And then they had our square footage, I think, incorrect, and I corrected them on the square footage. And I think that was about it, the fireplace and the square footage. And so I don't know that there was anything done about all these other conditions. They never told me about it. They never said we're gonna adjust for the fact that you've got to maintain your private road and do your own work on that. Nothing. I have no idea.
Okay. But you don't have any what you think your property might be worth?
What I believe my property is worth right now, today, with the surrounding external obsolescence, is $195,500.
Okay, thank you.
There's no other questions. That this time I usually will, we usually switch over to the assessor's office. I see Ms. White on the screen. Ms. White, whenever you are ready, I feel like begin to present your arguments about same sort of question I asked Ms. Muska, though, is usually if you can just identify what you were asking the commission to do today, but otherwise the floor is yours.
Is that for me, Mr. Pope?
Yes.
Okay, and I apologize if you all may hear some background drilling. They're doing that in the office that I'm in today. Good afternoon, everyone. Commissioners, as you know, pursuant to the Tennessee Code annotated 67-5-1506, There are a limit, you all are, of course, limited to the record here. And the record here, even though, is it Miss Muska? Did I say that correct, Muska?
Yes, ma'am.
Thank you. Has made some clarifications as to what she intended. The fact of the matter is that the assessor's office has appraised the value of the subject property according to accepted appraisal practices, and the assessor's office made the proper adjustments. In fact, they did make a land adjustment of 40%. Ms. Muska at the hearing had an opportunity to present any value that she placed on any kind of any type of value on any type of reduction she thought was appropriate or any type of adjustment, and none was stated at the hearing, and none has been stated here today, even though this body couldn't consider new evidence. I do want to make a correction that a field appraiser was actually sent out to review the property. And is it one more thing? Yeah, as of yet, we've not heard any argument as it pertains to any procedural or legal error that was made. So we're requesting that the previous ruling be affirmed.
Any questions for the assessor's office from our commission panel?
Mr. Osborne, you have questions?
No, I have no questions this time.
Mr. Prophet?
I just have one very quick question. So there's 40% adjustment on the land, and then was there any adjustment on the house for the location and the issues at hand?
Mr. Pope, do you want to answer that, or Mr. Moore?
That's all included. Hello, my name is James Polk. That is all included in the site evaluation on my adjustment grid. That is part of the evidence that you have that has been submitted by the assessor's office. So adjustment was made on the site value of the parcel.
Any other questions? I have no questions.
All right, then at this time, we usually go back to Ms. Muska for any final comments you have before we'll conclude and move into deliberations. So if you have anything else to say, Ms. Muska, the floor is yours.
Okay, thank you. No, I need to reiterate to Ms. White. Yes, a employee, Mr. Hall, did come out and take pictures right before the administrative hearing that I had February 13th of this year. Probably it may have been the last week in January, something, because all the leaves are down. And one of his photographs is there in this evidence. And oh boy, to go through all the pages, because I did see his photograph that he took of the front of our house, because all the leaves are down. So yes, he did take a picture of our house, and it's in these documents that the assessor provided. And then he took more pictures of the external obsolescence on the north side where the mobile homes were and are still, and across the street abandoned house, and then also house that has been neglected on the south side. So yeah, he took all the pictures. We also told him about the road, that we have to maintain this. He may have snapped a shot of Chaser Road, the pavement. I don't know, but anyway, so yes, he was out here. But all I've seen of what he took was just the front of the house.
If there are no final questions from our commission members, then
Does anyone?
No, I have none.
seeing and hearing none, we'll enter deliberations. So from here on out, there's no more communication between our commission and the parties. However, this is a public meeting, so they will deliberate in public and on the record and immediately. For clarity's purposes, I will just go ahead and say the commission will make a decision now during deliberations, but you will receive a final written order memorializing their discussion today. That if you want, you can appeal that order further. A couple of questions just to help guide the panel, essentially, and this is just another way to reiterate that basis for review I recited earlier. Essentially, do you find that the administrative law judge misapplied the law cited in this case? Did you find the administrative law judge otherwise act outside of their authority? Or do you believe the administrative law judge's decision was supported or unsupported by substantial and material evidence? So just some questions to help guide your deliberations, but we'll hand it over to Mr. Phil Russ, our presiding member, to preside over deliberations.
Okay, I'll start off. I think the situation with this house is unfortunate, but there is no factual opinions to disregard or to counter what the assessor has done. I think had there been an appraisal or something to with some concrete facts or normal appraisal type work could quantify any
I think your microphone might have gone out a little bit. Let me.
okay. The economic obsolescence is hard enough to quantify anyway, but there's none of that. The assessor's office did make an adjustment for the land value, and unfortunately for the property owner here, I mean, it sounds like that there are some real problems with the surrounding area. I don't think the center, the abuse center, if it's 7 miles away, if I do recall seeing some pictures in what was sent to us, that ought to be something that could be corrected pretty easily with the people who are running that center, that they wouldn't necessarily allow patients to get out in other people's property. But anyway, having said all that, I don't think we have any choice but to affirm the administrative law judge's decision in this. If someone wants to, well, everyone, Mr. and Mr. Prophet, y'all are welcome to make your comments, but I would entertain a motion for that. Mr. Osborne, if you want to go ahead.
Yeah,
Well, if we could just make sure you're really getting that microphone. Sorry, you can move it around.
yes, I totally agree. Is it working? Yes, I totally agree with you, Mr. Ross. I haven't heard any information that would compel me to believe that there's some factual information that's been overlooked or not considered by the administrative law judge. And that reason, I wouldn't see any reason to do anything other than affirm the administrative law judge's decision at this time.
The only thing that I see that looks like it's not really an issue, but because the complainant didn't really have a value other than just a little bit different from what I think it was Mr. Washington when he came out several years before. There wasn't any research or anything like that. The assessor's office, and what concerns me is they adjusted the land 40%, but they don't show, of course, in their paperwork, they may have shown they made all the adjustments in the land instead of on the improvement. I would like to have seen a proof of that on both, but there was no request for that, and it's not in the paperwork. So I make a motion that we uphold the administrative judge's decision.
Second. Am I allowed to make a second? As presiding?
You make a second, yeah.
Oh, okay, okay. All right, so, motion's been made and seconded, so all those in favor, please say aye.
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 Any opposed? Okay.
All right, I just want to note for the record too that we had all ayes, no nays. The motion to affirm the administrative law judge's initial decision and order is affirmed, or is carried. All right, so that concludes all our business for our first appeal. Today, we will send out a final written copy of the decision the commission made within the next 90 days, and available remedies will be listed at the end of that order. But that is all we have. So at this point in time, I usually like to check with our commission members. Does anyone need a break before we move on to our last appeal?
Now, are we allowed to say anything to Ms. Muska?
Yes, yes.
Well, I would suggest that if you really have a problem with this in the future, that you get a real estate appraiser, and if necessary, get two or something so they can do that. But that would be a suggestion for you.
And-
Well, in other words, an appraisal is best evidence of
Yes.
a value.
Yeah.
Yes.
And I'd like to add to that, you need to look at and see if the adjustment for the land included, if that was just lump summed into the land, if it's affecting the land by 40%, it should also affect the house quite a bit also. So there wasn't anything for us to go on that. So that's something, in the future, if you have problems, you may want to look at in like Mr. Russ was saying, you need an appraisal, independent appraisal.
All right. With that, we'll move on to our next appeal. I got an email and a couple of comments on here, just making sure. So before I launch into our next appeal, I want to make sure that we have everyone who's supposed to be here for that on the line. I got a quick note from the assessor's office that Miss Edna Smith will be presenting for the assessor's office for this appeal. And so I just want to make sure, Miss Smith, are you here and able to unmute? Did we get you into the call accordingly? I'm not seeing or hearing anyone from her. So we can try to give her a call here in a second. I think the last thing I got was she's able to call in, but she's waiting to be admitted, but I don't see her in the waiting room. So we will try to call her in a moment. Sorry, go ahead, Mr. Moore. Yeah.
Mr. Talbot needs to take a break if that's okay.
Okay, yeah. Like Mr. Talbot, if you can want to take a break, well, we'll also take a break. I'll just for timing purposes, we'll say about 10 minutes. So come back at 2:05 Central Time. And in the meantime, I'm going to see if we can get Miss Smith on the line. We won't start until 2:05.
Thank you.
Let me see. We're going to stay here, and I usually keep the recording going just to make sure we don't disrupt anything. Let me see if I've got Miss Smith's phone number. 615-399-3777 with an extension.
Tax management, this is Alicia. I'm the director call.
Hi, Alicia. This is Robin Pope from the Tennessee State Board of Equalization, where we've been trying to reach Edna Smith.
Okay, I can get you to her in just a moment.
Thank you.
Hello, you have reached the office of Edna Smith. Please leave a detailed message, including your name and phone number, and I'll return your call as soon as possible. Thank you.
You may start your message now. Press 0 to return to the attendant.
Hi, Ms. Smith. This is Robin Pope from the Tennessee State Board of Equalization. I know you're trying to join the hearing today. You really need to use the link to access or otherwise try to rejoin that meeting. I don't see you in the meeting, so we called you. I can give you a call back when we start up at 2:05. Otherwise, I'll kind of remove it so we stop leaving you a voicemail message. But the hearing is currently ongoing. We have our adjourned for a moment. We will come back at 2:05. Try to rejoin that meeting, and I will be here to see if we can admit you and get you on the line. Thank you. See if that was Miss. All right, Miss Smith, we heard you join. Let's make sure. Are you still there? All right, perfect.
Yes,
We
I
still
am.
about
Mhm.
we still have about 5 minutes till we get back on the records. Just stay on the line, and
Okay.
we'll be right back.
Okay.
All right, just about 2 more minutes.
You okay with that? Being in there? I can scoot down some more.
We just have about 30 seconds. Till we officially get back on the record. When we get back, I'll do it the way I'm should do it, which is make introductions, then read the order, and then we'll get started. Just to make sure everyone can hear and we can hear them before we get too far into it. Just about 5 seconds. 3, 2, 1. All right, I've got 2:05 on my state issued computer, so we will go ahead and get started again. Before we launch too far into it, this is our final appeal of today, Doubletree Memphis versus the Shelby County Assessor's Office. Before I get too far into it, I want to make sure we can get everyone heard. So we'll start with the representative for the taxpayer, which I believe is Mr. Lou Talbert. Apologize if I mispronounced that. I guess I have a habit of doing that. Mr. Talbert, could you give us a shout? Just make sure we can hear you. I think we can see you on camera.
Yes, sir. And I appreciate the break.
Absolutely, no worries.
I'm an older man that has high blood pressure, and I have to find the restroom everywhere I go.
No worries. And then for the assessor's office, I have a Miss Edna Smith as representing the assessor's office for this appeal. I guess let me know if that's not correct, or who will be representing the assessor's office.
Yes, that's me, Edna Smith, and I am the representative.
Okay, perfect. We've already made our introductions for our commission members, so I will. Okay. All right, Ms. Palmer, you might want to mute yourself if that's okay.
Sorry.
You're good. You're good. All right, reading off this initial decision order information. So I have initial decision order mailed out on June 8th. On the first page is the cover page and regarding Doubletree Memphis versus Shelby County Assessor's Office. Enclosed is an initial order including a notice of appeal procedures rendered in this case. I say that because on the first page of the actual order, we have that this is in the matter of Doubletree Memphis as the petitioner versus the Shelby County Assessor's Office respondent, APD case number 53.05-232001J. This is for SBOE appeal number 133223 for the personal property account number P083471, and then for appeal number 133224 for the same personal property account number, and then appeal number 137497 for the same personal property account number. And this covers tax years 2019, 2020, 2021. I will then note the first footnote in this on this first page identifies that the taxpayer moved at the hearing to include tax year 2022, and its request was granted without objection. I will then also note that in the administrative record for this case that it is appeal number SBOE appeal number 141042 with that same personal property account number, and that's for the 2022 tax year. Reading into the order, it commences with order, and then starts with on March 24th, 2021 and December 13th, 2021, the State Board of Equalization, hereinafter State Board, received appeals by Doubletree Memphis, the owner of the personal property in question for tax years 2019, 2020, 2021, and 2022. The undersigned administrative judge conducted a telephonic hearing of this matter on May 22nd, 2023. The following parties participated in the hearing. The appellant was represented by its tax consultant, Louis Talbert, hereinafter the taxpayer. The Shelby County Assessor of Property was represented by its attorney, Victoria Carpenter, hereinafter Assessor's Office. The Assessor's Office's witness, Edna Smith, and the following exhibits were introduced at the hearing. Exhibit 1, the Assessor's Office's position of facts, 2020. Exhibit 2, the taxpayer's tangible personal property schedule for 2020. Exhibit 3, the Assessor's Office's 2019/2020 audit review form. Exhibit 4, the Assessor's Office's 2019/2020 amended audit review form. Exhibit 5, the taxpayer's 2019 general ledger report. Exhibit 6, 2020 personal property valuation change authorization. Exhibit 7, the Assessor's Office's Exhibit 7, the Assessor's Office's request for information from the taxpayer. Exhibit 8, the Assessor's Office's position of facts for 2019. Exhibit 9, the taxpayer's tangible personal property schedule 2019. Exhibit 10, 2019 personal property valuation change authorization. Exhibit 11, the Assessor's Office's position of facts for 2021. Exhibit 12, the taxpayer's property schedule. Exhibit 13, the taxpayer's personal property petition appeal form. And Exhibit 14, the taxpayer's summary of evidence. In this state, all business and professional entities must report annually to the assessor, quote, all tangible personal property owned by the taxpayer and used or held for use in such business or profession, including, but not limited to, furniture, fixtures, machinery, and equipment, all raw material supplies, but excluding all finished goods in the hands of the manufacturer and the inventories of merchandise held for sale or exchange, end quote. Tennessee Code Annotated Section 67-5-903, subsection A. As the party seeking to change the current assessment of the subject property, the appellant has the burden of proof in this administrative proceeding. State Board Rule 0600-1-.11, subsection 1. The taxpayer's tax consultant, Louis Talbert with the Altus Group, testified that the taxpayer submitted a depreciation schedule that complied with the requested information from the assessor's office. The assessor's office's witness, Edna Smith, an auditor with Tax Management Associates, testified that the taxpayer only provided a summary of the depreciation schedule with detailed description of the listings of the taxpayer's assets. She further testified that repeated requests for the detailed listing of assets were not provided by the taxpayer. Ultimately, the issue comes down to whether the assessor's office is entitled to the requested information on the taxpayer's assets, which they are clearly entitled to receive and review. The taxpayer's representative provided no satisfactory response to explain the taxpayer's failure to provide the requested information. And then on page 3, due to the taxpayer's failure to provide the requested listings of assets to the assessor's office's valuation of the taxpayer's personal property for tax years 2019, 2021, 2020, 2019, 2020, 2021, 2022 are adopted, and the taxpayer's appeal of this matter is dismissed. It was then ordered. It is therefore ordered that the taxpayer's appeal is dismissed and the assessor's office's valuation for the taxpayer's personal property for tax years 2019, 2020, 2021, and 2022 are adopted. It is so ordered. This initial decision order being entered June 8th, 2023, and signed by Administrative Judge Jerome Cochran, concluding on the last page with available remedies, including appeal to this body, which is why we are here today. We also sent a notice of the administrative record, that is a full compiled administrative record, which included the acknowledgement of the appeal to the commission, a copy of the full certified technical record from the Administrative Procedures Division, the notice for a scheduling conference related to this appeal, and finally the notice of hearing before the commission regarding this appeal. I will note I did not receive any additional written argument from either party in advance of today's hearing. With that, we will otherwise hand it over to our appellant, which I believe is Mr. Talbert, on behalf of Doubletree Memphis. So Mr. Talbert, I usually do just ask everyone before they present to the commission, if you could describe what relief, what action you are asking for the commission to do today. It usually just helps guide things along, in my opinion, a little bit. But otherwise, the floor is yours to begin your argument. Once you've concluded, I'll ask the commission if they have any questions of you.
I'm asking the commission to require the assessor to sit down and look at the detail that we've tried to provide before, which they have denied. In other words, the assessor has chosen to take a summary depreciation report and arbitrarily say that everything on there is personal property, when it's been pointed out to them on numerous occasions that during the years covered by this audit, the taxpayer had gone through some extensive renovations. And there are many, many real estate items listed in the detail, items such as Benswanger Glass Company, kitchen air conditioner, ballroom air conditioner, interstate plywood, national wall covering, etc. And the assessor's people should know that in a hotel, you frequently are going to have items that are of a real estate nature that get depreciated in the personal property section to get that quicker write-off. Because no one wants to depreciate an air conditioner compressor over 30 years. And the assessor has just flatly refused to consider the fact that we've got some real estate items in that listing. The commission needs to require us to sit down together and have a conference with people that know a little bit about personal property and go over item by item and make a decision on a fixed asset list that we can both live with. Because the valuation they've got right now is a travesty of justice. It's 2.5 to 3 times more than what it should be.
All right. Any questions of Mr. Talbert from our commission members today? And we usually just go down the line. So Mr. Russ, any questions?
The only thing I can say is that there is a huge difference in what the assessor has come up with and what the taxpayer has come up with, without any real, I won't say effort, but it doesn't seem like it's pretty irreconcilable right now. I don't know the nature of what all the assessor has requested and has not received that might change their mind. But the question that really before this commission in my mind is the information was requested and not received, and the taxpayer at the hearing. And I guess but do you said in one of the things that we read that you didn't know why they hadn't sent that in, and you had no answer for that. So can you enlighten us any more?
Yes, sir. I would like to address the statement of requested and not received, sir. I admitted early on in this, in talking with the auditor and the assessor's people, that the client dragged his feet on giving me a detailed depreciation schedule. But we did receive one at the 11th hour. And I turned it over to Edna Smith, the auditor. And this is when she came up with a question on a $7,687 garbage disposal that I had missed in making the audit pack and the taxpayer had missed. And I had to agree with her that, yes, this should have been personal property. So I modified my fixed asset list and gave her a new copy. She had the opportunity to look at a detailed depreciation list. And I stand by that statement. Gentlemen, I was blindsided on November the 9th by a statement of position from the assessor. And let me say that I was under the impression that our responses were due by October the 26th, which I tried to comply with. Now I received an added response from the assessor on November the 9th, and I learned that we had until November the 9th for additional responses. I'm having a little dizzy spell, y'all. Forgive me. My blood pressure gets to me every once in a while. It took a while to get the detailed depreciation schedule. When we got it, we adjusted for this commercial grade garbage disposal. And I thought we had a good report at that point. So then when the audit report came out, it had this huge number on there. And I called Edna to ask the reason why. The audit lady. And this is what she told me, gentlemen. She said, when I discussed that with Barbara, Barbara said that since it was turned in so late, let's just ignore any details and go with the summary depreciation schedule. And if that's the case, anybody that's been in personal property should know that there are going to be items of a real estate nature that need to be excluded. And so that's what they did. They jacked it up with these larger numbers. And in the meantime, Edna and I tried to negotiate a settlement on this. And I'll just tell you, if you'll please accept my apology for the lateness of my additional statement of position and let me read it. I believe you'll see that I'm being as honest and straightforward as anyone you come in contact with. Edna and I sat down to look at this. Again, she had asked me for a detailed depreciation schedule because, embarrassingly enough, neither one of us could produce the one that we had. And again, the taxpayer was slow. Oh, y'all, I'm having one of these dizzy spells. I'm sorry.
Yeah, no, take your time.
Please understand the corporate controller in today's world is a man that works 55 to 60 hours a week, no matter what the company is. So the taxpayer personnel that I was asking was under stress to begin with, plus his mother has been in and out of intensive care. So again, he resisted reproducing that depreciation schedule. And he said, well, here's the deal on all of my other audits with TMA, which is several Tennessee packages. TMA will accept a general ledger printout that shows the detail that agrees to the items that are on that summary depreciation schedule. And TMA has told me in audits past that we know which vendors represent real estate and which vendors represent personal property, and we're good with that. And Lou, I've never had a problem like this on an audit before. And he did furnish me with a detailed general ledger printout, which I went over with Edna. And she seemed to accept the fact that there was a lot of items on there that represented payments to real estate vendors. Items such as John T. Campbell Company Roofing, $154,000. And so she was willing to ignore a lot of that cost that was real estate. And there were some vendors on there where she said, now Lou, some of these vendors, I can't tell quickly by the vendor name whether it is real estate or personal property. And she had a handful of those that she said she couldn't tell. And I couldn't give her any insight to on the side of either real or personal. And so I agreed to accept those as adjustments. And I added some $470-some thousand to my schedule that I thought was correct when we made the adjustment for the garbage disposal. And so I ended up with a modified fixed asset list that was a little hard to deal with. In other words, the modified fixed asset list was a huge number. It was $2,791,512, which is a lot more than what the client started out with, but it's still a lot less than what the assessor had taken off of the recap depreciation schedule that just had the totals in it. They had full cost of $6,650,000 on group one, and then another $350,000 on the other groups. So they had a total cost in the audit of $7,029,000, which is way different than $2,791,000. Y'all, I'm sorry, I'm having a dizzy spell again.
Oh, you're
And I'll
good.
tell you this,
I'm
pressure
a little
is
off track, Mr. Talbot. I'm just want to refocus to again, we're here to review the initial decision and order that I read at the beginning. The order from the judge was to dismiss this case due to, as on page 3, it says, due to the taxpayer's failure to provide the requested listings of assets to the assessor's office, the assessor's office's valuations of the taxpayer's personal property for tax years 2019, 2020, 21, and 2022 are adopted, and the taxpayer's appeal of this matter is dismissed. So that is the decision that was under review, and that's what we're here to hear arguments about, is why you believe Jerome Cochran's decision to adopt those assessor's valuations and otherwise dismiss your appeal due to failure to provide the requested listings of assets, whether that decision was, as I read at the beginning of today's hearing, I will state again. So the review for today is based on Tennessee Code Annotated 67-5-1506 before July 1, 2023, when the statute was amended. And so it stated that the Assessment Appeals Commission may affirm the decision of the hearing examiner or remand the case for further proceedings if they find the rights of the petitioner have been prejudiced because the administrative decision was in violation of constitutional or statutory provisions. That is, did the judge follow and apply the law correctly? 2, made upon unlawful procedure. Did the judge not follow some proper procedure, or was there some abuse of procedure by the judge? 3, was the decision arbitrary and capricious or characterized by an abuse of discretion or clearly unwarranted exercise of discretion? Essentially, was the judge's decision arbitrary? Or 4, was the decision unsupported by evidence that is both substantial and material in light of the entire record? And so in determining those facts, those decisions of fact made by the judge, the commission can look at the entire record and they can see there might be support for 2 opposing points of view. However, if the judge made a finding of fact, they cannot replace their judgment for that of the administrative judge. However, they are not required to ignore inconsistencies in the record. So those are the bases for appeal, basis for reversing the decision. And the decision, like I said today, that I read at the beginning of this this portion of our hearing, was to dismiss the appeal for taxpayers' failure to provide the requested listings. And so we're here to review the administrative law judge's decision on that matter and hear any arguments from you on behalf of the taxpayer about why that judge's decision should be reversed or is otherwise incorrect. I will say as well that if you would like, and if any of our commission members would prefer, we do have that audio recording of the hearing before the administrative judge, and I can play that for all of us today if you'd like to hear it. It's only 30 minutes is the length of the audio recording I have. If you would like to do that, we do have time. But so with that, Mr. Talbert, I just want to kind of focus this hearing that we're really looking at that decision of the judge, and if his decision to dismiss for failure to provide those requested documents was correct or not. With that, I'll kind of hand it back to you, Mr. Talbert.
Sorry.
I'm sorry, go ahead.
I'm sorry, this whole thing has hit me like a ton of bricks. Y'all don't know me, gentlemen. I've held a Tennessee CPI license for 50 years. If I was dishonest, my brethren in the CPA community would have run me out of town. Now, the judge has basically said that I lied when I said that we furnished a detailed appreciation schedule. I admitted that we furnished it at the 11th hour, but we did furnish one. And it's an embarrassment to me that neither Edna nor I can come up with it at this stage. But in the alternative, in trying to resolve this, I've done a few things, fellas. I've been a controller in some pretty big companies. One company I was a controller in, they entrusted me with the authority to wire transfer up to $5 million on my verbal command to the bank. Now then, on larger deals between 5 and 10 million, it took my verbal authority and the verbal authority from my boss. But I'm pleading with y'all that I'm a trustworthy person. I did not lie about that. And I am deeply offended that I've been called a liar by the judge. I'm having a little dispel again, fellas. I'm sorry. I can't help it. I'm not accustomed to being called a liar, and this has upset me quite a bit. If you talk to people that have known me for years, there are two words that they will mention to you, and that is honesty and integrity. So if y'all would indulge me, I prepared a response to this response I received on November the 9th.
No,
which, as
Mr.
I said,
Mr. Talbert, I apologize. That you have to be a little bit more specific about what you're referencing. We are not here to hear testimony today regarding what may or may not have happened at the prior level. We're really just reviewing that decision of the administrative law judge and any basis for that. If you would like to reference portions of the record, that's that notice of the administrative record or the certified technical record, you can do that, and we can get to that page number, and I can screen share and have us all on the same page. But we're not here to rehash necessarily things that may have happened previously. It's really just a review of that decision. And so we can reference portions of the record, but you really need to stay on task. That's my role, to try to keep this on the rails. We're really here to review that order and why you believe that decision was incorrect or correct. So I want to make sure we're staying on task on that is all.
Yes, sir. I don't mean to drag this out any more than it has to, but the assessor has dragged it out for 3 years now when it could have been settled a long time ago. And here's the deal. In the record, if you will look at Exhibit 14, Item 5, I gave
All right,
the
just give us a
judge,
moment, Mr. Talbert. Just give us a moment to get there. Whoever from the assessor's office put us on mute, I will reject you from the call in 2 seconds, and I'm going to eject them now. And I will not be readmitting Ms. Mrazel to the meeting. All right. I have a notice of an administrative record. Let's see here. A certified technical record. All right. It is a 304-page document that is page numbered at the bottom. I sent out a copy of this in advance to both parties. Do you have a page number? It should be labeled in bright red and bold. Doubletree Memphis AAC admin record, and then it has a page number on it. I can try to navigate through here. It looks like the certified technical record was on page 3, and it has a sub-paging enumeration within it. Jerome Cochran identified exhibits as pages 166 of the certified technical record. I will navigate to that in a moment as we get there. Just a moment. Just want to make sure we all are on the same page. Okay. On page 1 of the administrative law judge's order, he identified several exhibits. Exhibit 1, the assessor's office position of facts. I'm sorry, Mr. Talbert, you were referencing a specific exhibit. Which exhibit were you referring to?
it's Exhibit 14, and I don't have my copy of the complete 300-page record. So
All
I
right,
cannot
no worries.
tell
Hold
you
on a second. Let me get there. Let me get there. The Exhibit 14, the taxpayer's summary of evidence as noted on page 2 of 3 of the order. I'm trying to navigate through, and then I can get a copy for our commission members as well. Sorry, it's a large document, so I'm just trying to make sure. All right, I have a May 24th, 2023 letter from to Administrative Jerome Cochran. It looks like it is approximately 2 pages, and it starts off with regarding Doubletree Memphis follow-up to our May 22, 2023 SBOE hearing. Is that what you were referring to, Mr. Talbert?
The way my paragraph starts is, enclosed are the additional details relevant to the telephone
Yes.
hearing we had this past Monday.
Yes. Okay. I have that. Let's
That
see.
first thing you had was the cover letter, I guess.
Yes. All
If
right.
you start
All-
with
Hold
the
on a second.
items,
We gotta do a couple. We got more moving parts to this. All right. Just hold on. Miss Barbie, or
y'all, I'm
gonna
having a,
yeah, just hold on. We're not moving anywhere. We're just getting printed copies for our commission members. Miss Barbie, I'm gonna print off oh, okay. Yeah, we're holding off.
You having a seizure?
I don't know if I am or not.
Might want to go get medical.
Do what?
You need some, see, is anybody out there?
You think we need to get somebody in his hands though?
Well, what I need is for this thing to be took care of in the right way.
Okay.
I'm sorry, I appreciate
He
you.
going in and out. I think he having.
Because I think I did have a mild seizure.
Yeah,
Yeah,
we're gonna take a break. We're gonna take a break. We'll come back. We'll try to come back. Just take a break. We'll come back
Can you
at
give me
about
some
3 o'clock. We're not going
Some
anywhere.
crackers and maybe a Diet Coke or something.
Okay. I got something in my office.
Gentlemen, I'm sorry about this. I had a real light lunch trying to get here in time for this. And I'm
You're
diabetic.
good.
I should have had a better lunch than what I had.
Okay.
You're good. Let's take a
Step
like 20-minute break. We'll come back at 3 p.m. We're not going anywhere. We'll come right back. Do what you got to do.
You need
We'll
some
come
money
back
to get
at
break?
3
No, sir. Let it be okay.
at 3 p.m. Central.
All righty. And I'm sorry about this too.
You're
Very
no,
much.
I totally understand. Totally understand. We'll come back at 3 p.m. Central, and we'll get a printed copy of those for our commission members while we do that. So just take a deep breath, a deep break, and do what you got to do. We'll come back at 3. I've got 3 o'clock on my state issue computer. I just want to double check. I think I've got a copy of that printed document we were reading coming down. I just want to check with the assessor's office. Are y'all okay?
No, Mr. Pope, we had to call the paramedics for Mr. Talbot. It's
Okay.
looking like we're probably gonna have to reschedule this hearing.
Okay, we can do that.
Hi,
Hi.
how are you?
Hi.
What's your name?
My name is Nathaniel Lewis Talbot, and I'm a CPA.
All right. What's going on today, Mr.
Okay.
Talbot?
Mr. Moore, yeah, you
Ever
can
got
you can disconnect. We'll get back with you.
Before?
Thank you, Mr. Pope.
Well,
Thank you. All right, and for everyone else on our hearing, I guess Miss Smith, it looks like we're gonna have to reschedule this hearing, the rest of this hearing, for another time. We've got very limited dates left available, so I will work with the parties to reach out to them and get back to y'all on that. Most likely February, one of those dates in February. That'll conclude our proceedings today. Thank you very much. Everyone on the call, I'll go ahead and I guess end this meeting. Yeah, I kind of want to dismiss everybody, but at the same time, I'm like hoping not hope, but we'll just call it. We'll just wrap up. We'll reschedule. Okay.
Okay.
With that, I guess our meeting today is adjourned. Thank you all. Thank you, commission members, for serving. We'll see you all next time.